Hello everyone. Today we are going to discuss the nature of constitution and how to understand the Indian constitution. As you are all aware that this depends upon how we look into the matter in which a constitution is formed. Moreover, this topic is essential for Union Public Service Commission examination as well as other examinations. Therefore, in this precise module, we will be discussing following topics. First, we shall discuss the nature of the Constitution, work of the Constitution, what do we mean by the Constitution, the idea of age of modern constitutions, how to classify a constitution, as well as work of the Constitution in a detailed manner, rule of law, and constitutionalism. This list of subtopics are precise in nature and they will definitely help you in dealing with questions that are asked from different vantage point in the UPSC examination or any other examination you are preparing. Defining the Constitution. Now, as far as this term is concerned, there can be different ways in which you can define the Constitution. Well, some say it is a written document, some say it is unwritten document, etc., etc. However, if you want to be precise in your argument, a constitution could be a set of written rules or even unwritten rules, but majorly it is the supreme authoritative document in a political community. Now what happens? Once you look at this supreme document, it means that it is the highest law of the land, which is followed by almost every unit in the polity. Now the question emerges, what is the meaning of supreme, what is the meaning of authoritative, and what is the meaning of document, and what is the meaning of being the highest law of the land, as well as what is the meaning of political community. Now these are different concepts used in political science by many scholars. As far as the idea of authoritative document is concerned, it means that this document possesses authority. It is not simply based on power, rather power has become legitimate. It could become legitimate through variety of means. Maybe the unit that comprised and drafted this document was chosen by the people, either directly or indirectly, or the kind of political system that this unit actually led to has received persistent support and consent of the people at large. So there are two prime ways. I mean, there can be many ways, but these are fundamental ways in which we can have an understanding about how something transforms from power into authority. The idea of document here is that there can be a written constitution, there can be unwritten constitutions, but at this moment, majorly, when we look at a constitution and think about it as a document, what we precisely mean is that almost or majority of legal provisions operational in a polity have been codified under a single document. This is what we mean by the idea of document. As far as the highest law of the land terminology is concerned, there can be different constitutions in a polity. There can be a constitution of a political party, there can be constitution of a university as well as some other institution. Then there are laws that are made by the parliament, there are laws that are made by the executive while exercising their legislative power granted by the constitution, but all these laws are beneath or they are in a subsidiary position to the law of the land. So this is what is the meaning of being the highest law of the land. As far as the term political community is concerned, we should be aware that there are four primary things in a political community. Number one, at the center is a rational and reasoned individual who has to some extent a kind of separation from ascriptive identities. Second, there is of course a political institution named state. Third, there is a government that is often considered as the administrative hand of the state. And fourth, the government is based on consent, which means people at some point in their political timeline If they don't agree with the government, they have the opportunity through democratic means, through non-violent means, to change the government. Let's move forward. Then, it develops the necessary mutual trust and a sense of cooperation among the different individuals living or operating in a political community. Moreover, if you think in narrow sense, the major aim of the constitution is to codify the constitutional provisions in the polity. As I discussed this thing in a different way when I was discussing with you the term document present in the second point. And if we think in the broad way, then we find these major work of the constitution, which are: number one, it seeks to establish the duties, powers and functions of the various institutions of government. Number two, it regulates the relationship between these various institutions or organs of the government. And number three, it defines the relationship between the state and the individual. And here, by the term individual, I'm using it in a generic sense. It also includes, let's say, citizens as well as other human beings in a polity who could be citizens of the nation state or who could not be citizens of the nation state. Let's move forward. Now there are three questions which you can think upon or ponder upon and you can try to answer. One is, why is the constitution called an official document? Second, why is the constitution considered the supreme law of the land or the nation? And third, why is the constitution found in the political community rather than in a society? Now in the previous slide, I have tried to explain every single point related to these questions. I will recommend all of you to please write down at least 50 words in defense of your answer or what you think could be the right answer. This will help you to clarify and get a clear understanding of the concept that you have just understood and read. Let's move forward. Now, let's move on to the idea of work of the Constitution. Now here I have tried to provide you a list. Very simple. It goes like this. First, it decides the form of the government and puts limits on its authority. Now from this first point, UPSC had asked a question like, what is the meaning of a constitutional government? And the answer was, the constitutional government means a limited government. So here the constitution tries to put limit on the authority of the government. Second, the constitution determines and outlines the separation and division of power between institution of states and organ of the government. So what it means is that on one point we have a separation of power between different organs of the government, legislature, executive, judiciary, as well as subsequent and in correlation to this separation, we also have a division of power between different levels of the government, which is the union level, the state level, and the third level, or the, as it is mentioned in the constitution, the lower level of the government, a self-regulatory framework that is not separate from the other units of the government or levels of the government, but it works with them to become autonomous. Third is, it provides a balanced framework of institutions to restrain centralization of state power detrimental to common good. Now, many times you all write words like concentration of power or deconcentration of power. If you are preparing for UPSC, don't use these vague statements. Rather, you should always try to write like this, that centralization of state power. Why? Because it is detrimental to common good. Moreover, if you are reading this while linking it to the concept of doctrine of separation of power, you can write in a way that it is detrimental to ensuring and maintaining individual liberty. The democratic constitution divides the power of the state into the legislature, executive, judiciary, independent constitutional bodies, thereby restraining the possibility of concentration of power under a small group or individual that could potentially destroy the constitution for the fulfillment of their whimsical or virulent purposes. Next is that the constitution establishes relation between citizens, individuals, communities, groups, and the state. Moreover, it sets up the rights and reciprocal obligation and duties. It also acts as the highest and moral and authoritative law of the land. The constitution further sets up the moral aims, goals, and end destination of the state or polity towards which it must orient itself, and finally, the Constitution establishes the basis of administration of the country, outlining the basic structure on which polity shall get constructed. So, in a nutshell, if you think about the topic works of the Constitution, we can begin like this. If we move forward, the idea or the question remains, what do we mean by the Constitution? Now, this is different from the idea of defining or providing a definition of the Constitution. Here, we are majorly concerned with what do we mean when we use the term Constitution, and I would like to add here that here we enter the idea of modern Constitution. So it goes like this. Behaviorally, many kind of constitutions are present in a political community. As I already discussed in the first slide, there could be constitution of, let's say, universities, training academies, communities, social groups, etc. But by the term constitution, we are concerned with the principal supreme authoritative document at the level of nation state, whose basic structure, rules, norms, laws, normative values determine the functioning and working of the political system or polity. So suppose you have to write a big statement or something, you can use this in your answer. Moving on, the next is the idea of age of modern constitutions. Now here, let me discuss it very clearly that there can be different kind of constitutions, and constitutions have existed over time in different kind of political communities. But when we are discussing the term constitution here, we are primarily concerned with modern constitution, and modern constitution term is categorically referring to specific nuances in the way constitution has changed over the history. So let's move on to this topic. Now how it goes like this. It began from the late 18th century. The Treaty of Magna Carta 1215, which is organically attached with the history of rule of law as written by Professor A.V. Dicey. Here, the Treaty of Magna Carta is indeed considered as the first attempt to draft a constitution. It also enjoys the status of being known as the first constitution of the world. But the usage of the term era of modern constitution is associated with the coming into force of those constitutions that were codified in a single document, like the United States Constitution of 1787 and the French Declaration of the Rights of Man and the Citizen in 1789. Now definitely we can critique here that why it is the Declaration of Rights of Man and the Citizen, but I think with momentary development, I guess we can understand that perhaps now this term man is being used here in a gender neutral sense. Moreover, there is one fundamental argument which I think all of you must be aware about, and this is that the making of constitution marks a rupture moment. It is seen as a hallmark of change and difference in the polity formation. It reflects extraordinary circumstances such as war, disturbance, or national independence. So for today, I think it's a small video, but like an introductory video, we stay till here. And in the next video, I will discuss other topics from this first module. Thank you.